द वे फॉरवर्ड इज ਤੁਹਾਡਾ ਬਹੁਤ-ਬਹੁਤ ਸਵਾਗਤ ਹੈ। ਮੈਂ ਤੁਹਾਡਾ ਹੋਸਟ ਹਰਜੋਤ ਸਿੰਘ। ਅੱਜ ਅਸੀਂ ਤਿੰਨ ਐਸੇ ਇੰਪੋਰਟੈਂਟ ਸੁਪਰੀਮ ਕੋਰਟ ਦੇ ਡਿਸੀਜਨਸ ਦੀ ਗੱਲ ਕਰਨ ਜਾ ਰਹੇ ਹਾਂ ਜਿਨ੍ਹਾਂ ਦਾ ਸਾਡੇ ਉੱਪਰ ਔਰ ਇਸ ਮੁਲਕ ਦੀ ਸਾਰੀ ਜਿਹੜੀ ਕਨਸਟੀਟਿਊਸ਼ਨਲ ਡਿਵੈਲਪਮੈਂਟ ਆਪਾਂ ਦੇਖ ਰਹੇ ਹਾਂ ਉਸ ਦੇ ਉੱਪਰ ਬਹੁਤ ਵੱਡਾ ਉਸ ਦਾ ਅਸਰ ਹੈ। ਅੱਜ इन तीन डेवलपमेंट्स बारे गल करन लई असी इनवाइट किया है कंट्री दे वन ऑफ द फोरमोस्ट कॉन्स्टिट्यूशनल ते एडमिनिस्ट्रेटिव लॉ दे एक्सपर्ट प्रोफेसर जैक बियरमैन जो कि बॉस्टन यूनिवर्सिटी स्कूल ऑफ लॉ विच एक प्रोफेसर है। प्रोफेसर बियरमैन, thank you so much for taking out the time. You're very welcome to the Way Forward show.
Great to see you, and it's great to see you, and it's great to be here.
Professor Behrman, I'll take the liberty of calling you Jack. We have known each other for a long time, and we meet in the circumstances where it's very phenomenal what has happened in the last 1 month. Supreme Court has given 3 landmark decisions which are going to influence our life directly, touch our life directly for a long time to come. We will be talking about those 3 decisions today. One is the one that has overturned Roe v. Wade, which was the law of the land for last 50 years. Then we'll talk about the expansion of gun laws in this country, wherein a 103-year-old law from New York has been struck down. And the third, a very important judgment, a very fundamental blow to environmental protection in this country, the EPA decision. Thank you so much again for taking out the time. First of all, I would like you to explain to our viewers what do we understand by precedent in this country for the Supreme Court? Because we understand at least 2 of these decisions. The Roe versus Wade decision was good law, reaffirmed several times for the last 50 years. And the gun law, which before 2008 stood good for at least 70 years, they served as precedent. But now it has been overturned. Can you please explain to us how does this work, the system of precedent in the Supreme Court?
Okay, great. Yeah, well, the theory is that judges are supposed to apply precedent, and that precedent is supposed to be binding on the courts, including the lower courts and the Supreme Court. Except that the Supreme Courts in every state and in the United States have always had the power and the authority to overrule their prior decisions. And at one time, it was thought they would only overrule them if they decided they were wrong. But in more recent years, it seems like the Supreme Court is willing to overrule decisions because it just no longer supports the views that were expressed in the earlier decisions. And in a certain sense, that kind of flexibility is good because as society changes, you don't want to be tied to law that sort of is outdated and doesn't work any longer. But on the other hand, it raises a question about the legitimacy of judicial rulings because the justices aren't elected; they're appointed, and when they go before Congress to have their nominations confirmed, they always say that they're going to follow the law. And in fact, some of the members of the Supreme Court specifically said that Roe versus Wade was precedent, which implied that they weren't going to overrule it, but yet they did. But they've always had this power, and one of the landmark decisions in our law is Brown versus Board of Education, which declared that separate but equal was no longer a proper understanding of the equal protection of the laws. And when they did that, of course, they overruled a very old precedent of Plessy versus Ferguson, which had said that separate but equal was consistent with equal protection of the laws. So it's nothing new. It seems to be a little bit more active and controversial these days, but it's always been part of the role of the courts to revisit their prior decisions. The lower courts have to follow what the higher courts say, though, until the higher courts change their mind.
Mm-hmm. But Jack, when we have this process of confirmation in the Senate, and as you said, all these 3 judges, they went there during the hearings. They said that Roe versus Wade is the law of the land. It has been reaffirmed, and it always sounded like they were not going to touch it, and then they turn around and overturn it. there's some noise in the Congress. People are demanding that does this amount to misrepresentation? Does it amount to lie? Is there anything which the system holds against this kind of active role by the Supreme Court judges during the confirmation?
Well, theoretically, of course, the Congress can impeach the justices. The House could impeach them, and the Senate could put them on trial. And but it's extremely unlikely. For one thing, these are all pretty good lawyers, so they never actually said, "I promise not to overrule Roe versus Wade." Mm-hmm. And so when if you would have asked them, "Can precedents be overruled?" they would have said yes. They would have had to say yes. And they never said they would promise absolutely not to overrule Roe versus Wade. But in political reality, they would never be impeached. When the Supreme Court decided Brown versus Board of Education, mm-hmm. There was a big movement in the South, and you could see big billboards were put up, "Impeach Earl Warren," who was the Chief Justice of the Supreme Court at the time that the Supreme Court outlawed segregation in schools. And so, theoretically, they could try to impeach the justices, but they won't, and they wouldn't succeed because they wouldn't have enough votes. And in any case, the justices really didn't lie. They treated it as a precedent, and precedents can be overruled.
So, Jack, let's go to the merits of these cases. What was Roe versus Wade that has been overturned now? Okay,
so back in 1973, the Supreme Court decided that abortion was a fundamental right under the Due Process Clause mm-hmm. that could only be restricted when the government has a compelling interest. And at that time, the court set up a trimester system, which said basically in the first trimester, the government has almost no interest in the potential for life. In the second trimester, because of the possibility that the surgery is more complicated, they can regulate things like, where the abortion takes place and such. But only in the third trimester could the government place significant restrictions or even prohibit it, because there, when the fetus is possibly capable of living outside the mother, then the government's interest in the health and life of the fetus is compelling. Later, the Supreme Court changed that in a case known as Casey to say that the government couldn't put an undue burden on a woman's right to choose abortion. And so you would get things like, does a woman have to notify her husband for the abortion? And the Supreme Court said no, that would place an undue burden on the woman. As far as a child having to notify her parents, the Supreme Court said that could be an undue burden if she's estranged from her parents, but she would have to go to court to prove that before she could have an abortion without parental notification. Otherwise, parental notification was fine. So the Supreme Court, through various twists and turns, had actually over the life of Roe versus Wade, had made it easier for states to restrict abortion. They had cut back on the original rule, but it was not until obviously very recently that they threw it out altogether.
Mm-hmm. But did the court recognize that there was a constitutional right to abortion in Roe v. Wade?
Yes, the court did. But there's nothing in the Constitution, obviously, that mentions abortion. Mm-hmm. They said it was part of due process. And due process is sort of been used by the courts as a catch-all to establish rights that aren't enumerated in the Constitution. And so things like the right to use birth control mm-hmm. and the right to have same-sex relationships and have same-sex marriage. Those are things that are understood as a matter of due process, even though, again, the Due Process Clause doesn't really say anything about abortion or about those other rights. So it's been judicial creativity to some would say update the Constitution, and others would say to seize power over the Constitution for themselves rather than respect their proper role, which is only to interpret the law.
So what does this decision that we had on June 24th say?
It says that there's absolutely no constitutional right to abortion. And basically what it says is that under the Due Process Clause, the only rights that are considered protected are rights that are sort of traditionally well established in our understanding. So that it's just, we can't imagine a system of liberty without that right. And the court said there was no tradition making abortion and allowing abortion. In fact, it's, there's been laws prohibiting abortion at the state level for over 100 years, maybe longer. And it's been even longer than that abortion has been generally thought to be a bad thing and not a right to do. And so that because that right, there was no traditional recognition of the right to abortion, and it wasn't necessary to preserve basic liberties, the court said that there is no right to abortion. It basically just erased Roe versus Wade from the law books and said it no longer exists at all.
So Jack, does this stay limited to abortion, or we might see expansion going into same-sex marriage and contraceptives as well?
I think there's a chance. I mean, the court in the opinion said very specifically that it was not addressing any other rights like contraception or same-sex marriage or same-sex sexual relationships or other aspects of the right to privacy. But Justice Thomas, in a concurring opinion, said that he thinks that this was a good step in the right direction, but that all those other rights ought to be revisited. And basically, he has consistently, for his entire 30 years on the Supreme Court, he has consistently said that there should be none of these due process rights, that due process does not protect things like this, that due process is basically about the procedures the government has to follow when deciding things that affect your life, liberty, or property, that it's not about creating rights. So the majority said, no, we don't intend on doing that. But they've said that before. There are other instances in which the majority of the court will say, well, we're deciding this one case, but we're not saying anything about something else. And then later on, when the next case comes about the something else, they say, oh, yeah, well, under the principles of that earlier case, we really have to change that law also. So the idea is that the court looks to its decisions for the underlying principles rather than just simply for the black letter rule of the law. So I think people are justifiably concerned that other rights might be up for grabs. Things like, again, same-sex marriage, the right to use contraception, other things like that.
So what essentially the Supreme Court is saying is that the Constitution does not directly provide a right to abortion. If there has to be a right to abortion, it has to be done by legislature, that too at the state level. Is that the ruling of the court?
Legislation, but also the possibility that the state courts themselves could recognize fundamental rights to abortion under the state constitutions. That is, what the U.S. Supreme Court says about the due process clause of the U.S. Constitution is not binding at all on what, for example, the Massachusetts Supreme Judicial Court says about what those similar clauses in the Massachusetts or New York constitutions say. So the New York Court of Appeals, which is the highest court in New York, as you know, could announce a right to abortion under the New York Constitution. I believe that a judge in Minnesota just recently, in the last few days, announced that abortion rights are protected in Minnesota under the Minnesota Constitution. And in fact, a justice of the Supreme Judicial Court here in Massachusetts just recently published an article encouraging state Supreme Courts to be more active as the U.S. Supreme Court starts cutting back on rights. And this has happened before in the 1980s when the judges that Ronald Reagan appointed to the federal courts came on. There was encouragement of state judges to look to their own constitutions rather than to federal law. So there is a chance. There's also a chance for some federal executive action, which is sort of interesting. I was thinking the president has mentioned things about this.
Yes. Jack, we'll take a small break here, and when we come back, we'll talk about these executive actions that the current president is looking to take as well. ਅਸੀਂ ਇੱਥੇ ਇੱਕ ਛੋਟਾ ਜਿਹਾ ਬ੍ਰੇਕ ਲਾਂਗੇ, ਤੁਸੀਂ ਵੇਖਦੇ ਰਹੋ The Way Forward. The Way Forward is ਤੁਹਾਡਾ ਫਿਰ ਤੋਂ ਸਵਾਗਤ ਹੈ, ਮੈਂ ਤੁਹਾਡਾ host Harjot Singh. So Jack, before we went to the break, we started talking about executive action and possibility of executive action on this, particular area. Roe v. Wade came 50 years back, but there was no attempt by the Democrats to codify that law. I don't know why did that happen. And even now, whatever action President Biden is proposing lacks the teeth to actually do something about the issue. Is that fair to say?
Well, it's very difficult because, the president only has whatever powers the Constitution and laws give the president. And so the president can't create law on his or her own. We've seen many controversies over that. in the Obama and the Trump administrations, and it actually goes down goes back way farther than that when presidents try to do things on their own. Mm-hmm. As far as Congress not ever codifying Roe versus Wade, well, that, of course, you don't pass a statute that you don't feel you need. The one Congress did very often restrict federal funding for abortion. So I think it would have been unrealistic to actually try to protect abortion rights by U.S. law. If anything, the members of Congress would have, especially in certain times when the Congress was more conservative, they might have actually tried to restrict abortion rights, which they did by prohibiting the use of federal funds for abortion. But there are certain things that the president might be able to do. For example, ordering, changing the law to allow, for example, members of the military and all federal employees to either get abortions on federal installations in the states, even where abortion is illegal, or, if necessary, give people leave and funding to travel to go to a place where abortion is legal. And it's a little unclear because, the practice of medicine is basically controlled by the states. Doctors are licensed by the states. And so a doctor practicing medicine in a state where abortion is illegal presumably could get in trouble for it and be prosecuted for it, even if they're doing so at a federal hospital. Imagine all the federal hospitals there are for the Veterans Administration, for example, mm-hmm. and or doctors treating veterans and such. Could they probably have to follow state law in the state where they're located. But the president can do things like provide for funding for federal employees to use their benefits to go to states where abortion is legal. Whether they can do things for other people that have no association with the federal government, it's a little bit unclear, but I'm sure that there are creative lawyers and policymakers in the White House right now that are trying to figure out ways to do it.
When the president came out this Friday announcing the executive plan, a lot of people were expecting that he might do something like allowing abortions on federal land, but he did not go that far.
Yeah, and I think that's because of this uncertainty about who has the authority to regulate the practice of medicine, even on federal land. Mm. That is, federal. Just to give a simple example, the Postal Service trucks have to follow the local speed limit. Mm. They can't drive however they want just because they happen to be federal vehicles. So if you have a hospital that's on federal property in a state, a federally run hospital, those doctors are probably still bound by their obligations under their licenses under state law. And all the other people who are practicing, it's a little bit vague. There have been some cases you may have noticed about American Indian law lately, where there's been some controversy about whether local government in Oklahoma can enforce its law, because so much of it, that area was actually a reservation controlled by the American Indians. And the Supreme Court made one very pro-American Indian decision last year, and then this year they cut back on that and said that the local governments can still do prosecutions in area that's considered part of an American Indian reservation. So you have a lot of uncertainty about that sort of thing. So I think the biggest question would be if a state tries to punish someone for traveling to another state to get an abortion, or tries to punish people who help that person travel to another state for abortion, whether that would be something that would be unconstitutional as violating sort of the federal structure. And I think the chances are that states could not punish people for that sort of conduct. I think only the federal government can regulate interstate travel for whatever purpose.
Mm-hmm. Jack, I'll ask you a fundamental question. The whole opposition to abortion is based on religious principles of some people. They see it as a sin against God or against their religious beliefs. Isn't this whole idea of opposing abortion imposition of somebody's religious beliefs on the whole country?
Yeah, I think that there's a good argument that that's the case. I think as a technical legal matter, it doesn't violate any sort of separation of church and state to have laws on the books that are motivated by people's religious beliefs, as opposed to laws requiring people to practice religion in a certain way. In other words, for example, someone could say, well, why are you against murder? And they say, well, the Ten Commandments, it says thou shalt not kill. So so does that mean all murder laws supported by people that believe in the Ten Commandments are suddenly, violating the separation of church and state? No, that as long as the law serves a government purpose, it doesn't violate the Constitution to have the law be motivated by people's religious beliefs, whatever they are. But in this case, what you do have is you have sort of a very strongly held religious view be the primary motivating factor for many, many of the people that oppose abortion. So it does feel like one religion is imposing its views. And it's not a surprise, of course, that on the Supreme Court, I think 6 of the 7 Christians voted in favor of overruling Roe versus Wade. That the two Jewish justices voted in favor of upholding it, and then one Justice Sotomayor, who's Christian by heritage, voted to preserve it. But you have 6 justices who are known to be Christians voting to overrule it. So it does feel that way, and but it's not a violation of any principle of separation because of the fact that there's a legitimate secular purpose in prohibiting abortion. It's not only to save someone's soul; it's also to, according to these people, save at least the potential life of the fetus.
Mm-hmm. So, Jack, one thing we got from this decision was the court said that it should be left to the states to decide whatever they want to do themselves. A federal government shouldn't be imposing. But contrary to this, what we have seen in the gun debate is there was a law from New York State which the Supreme Court has invalidated as opposing Constitution, the Second Amendment. Can you throw some light on that as well? How does that happen?
Okay, well, anytime the Supreme Court enforces a federal right, whether it's specifically named in the Bill of Rights or something that comes from a more general constitutional provision, obviously that imposes federal law over and above the state laws. The Constitution is very clear that when there's a valid federal law on the books, any state law to the contrary is superseded. It's the federal law is the supreme law of the land. Mm-hmm. So, you point out sort of an inconsistency. In some cases, the same justices who seem very concerned with preserving state power don't seem to mind overruling state power in other cases. But of course, that goes both ways. That is, you'll see justices who are liberal justices who are inclined to recognize rights sometimes claim that the states shouldn't be able to violate certain federal matters. So it's that's an argument that's used more as an argument than in an actual deciding principle. But yes, so the first the Bill of Rights was originally supposed to apply only to the federal government, and each state was supposed to be free to make its own rules. And in many cases, the Supreme Court said that gun control was a matter of state and local law, not federal law. But now they've changed their mind based on what they claim is a new reading of the original intent and meaning of the Second Amendment.
Mm-hmm. Jack, we'll talk more about this after a short break. ਅਸੀਂ ਤੁਹਾਨੂੰ ਮਿਲਦੇ ਹਾਂ ਇੱਕ ਛੋਟੀ ਜੀ ਬ੍ਰੇਕ ਦੇ ਬਾਅਦ। ਤੁਸੀਂ ਵੇਖਦੇ ਰਹੋ The Way Forward। The Way Forward is ਤੁਹਾਡਾ ਫਿਰ ਤੋਂ ਸਵਾਗਤ ਹੈ। ਮੈਂ ਤੁਹਾਡਾ host Harjot Singh. Jack, we started talking about the Second Amendment before we went to the break. Before we discuss this Supreme Court ruling on the Second Amendment and expanding of the gun laws in this country, or I would say putting some control on regulation of guns is going to make regulation more difficult. Can you tell us something? What is the Second Amendment? What do we understand by Second Amendment?
Okay, so it's very interesting. The Second Amendment is one of the more interesting provisions of the Constitution, and it has an interesting history, but excuse me, I knew that was going to happen. It begins by saying that mentioning a well-regulated militia. If you read the Second Amendment, it starts by saying a well-regulated militia being necessary, and then it goes on to say that the right to bear arms, the right of the people to bear arms shall not be taken away. I'm paraphrasing, but the reason that's interesting is because the history of the Second Amendment comes out of one of the biggest arguments that happened at the time the Constitution was written in 1787 up till 1789. Because what happened was there was a big fight over whether the federal government should be able to have a standing army, or whether the federal government should just have the authority to call out the state militia if there was an invasion or some reason, an insurrection that they needed to put down.
So the state militia, was it a regulated army of the state, or what?
So yeah, the state militia was part of the states, and under the previous constitution that we had for only a few years, called the Articles of Confederation, the federal government could not have an army. That it just relied on this individual, what they called the militia of the states. So the compromise was basically the Second Amendment, which was passed after the Constitution, but right after. The compromise was that the federal government could have a standing army, but the federal government could not interfere with the state militia. And basically, the definition of the militia is that all men of military age, at the time only men, would be subject to being called out to fight. And they would need their weapons either sometimes at home or sometimes stored in an armory run by the state, where they would go get them in case they were called out. Okay, so now, and in fact, allowing a standing army was so controversial that one of the framers of the Constitution, when he lost the argument against the standing army, he refused to sign the Constitution. His name was Elbridge Gerry, and he was from Marblehead, Massachusetts, right next to the town that I live in. And he's famous now, not for that, but for the fact that he also drew a crazy-looking district to make sure that he could get elected to Congress. And it's now called gerrymandering, because his name is Gerry. And only in Marblehead they call it gerrymandering, but everywhere else in the country they call it gerrymandering.
Gerrymandering, yeah.
So he refused to sign the Constitution because he didn't want the federal government to have an army. So it was always understood that the Second Amendment only restricted the federal government's right to regulate weapons, that it was up to the states to regulate weapons, that they were hands off the state militia and they couldn't regulate guns. But in the early 2000s, in a case against the city of Chicago, the Supreme Court overruled more than 100 years of clear precedent and decided that the Second Amendment applied to the states and local governments. It had already decided that the Second Amendment gave a fundamental right to own weapons for self-defense. That came up in a case about Washington, D.C., and Washington, D.C. is the federal government, so you didn't reach the question of whether it also applied to the states in that case. But in the McDonald case, which was about the city of Chicago's gun control, the Supreme Court decided that the Second Amendment also applied to the states, which seems odd to historians, but the Supreme Court had a new version of the history of the Second Amendment. And they did, they just, this is part of the problem with Supreme Court decision making based on original intent, is that for many historians, they think the Supreme Court is pretty bad at reading the history, and that they just basically rewrite the history to suit their political views. And so as you get a stronger and stronger pro-gun movement in the United States, you get a Supreme Court reflecting that, and suddenly more than 100 years of law is thrown out the window, which says the law that says the states can regulate guns, and you have now the Supreme Court of the United States deciding on gun control.
So it was basically a debate whether federal government controls or the state government's control. How did it become a right of an individual? Was that after the Heller decision in 2008, when they said
Yes, the Heller decision decided it was a fundamental right. That the best reading of the Second Amendment, based on history, was that the Second Amendment was intended to give people an individual right to own guns for self-defense, which in my opinion turns it totally on its head. Because in my opinion, the Second Amendment was about giving people the right to have guns available for use in military matters, that is, in the militia. So it's wrong, in my opinion, on two counts. Number one, because it doesn't apply to the states, and number two, because it had nothing to do with guns for self-defense. It had everything to do with military weapons. I'm not saying that I think people should be able to own, military weapons, but I'm just saying that it really wasn't about personal guns for self-defense.
So this interpretation that Second Amendment gives individuals a right to own guns to fight the federal government if federal government involves itself in tyranny on individuals or on the states. Where has that interpretation come from?
Okay, now that I didn't say that, and that actually, the right that they said was the right to own weapons for self-defense.
Mm-hmm.
Okay, and when the Supreme Court didn't talk about using guns against the government. But there are many popular groups that say that the reason for the Second Amendment is to prevent the government tyranny. But I don't think there's any private group of people, no matter how many weapons they have, I don't think there's any private group of people that are actually pose any serious threat to preventing the government of any state or the United States from executing whatever the laws that it wants to. So I think that's just sort of more of a rhetorical idea.
And if we go by that understanding, does that mean that individuals are allowed to have submarines, they're allowed to have tanks, nuclear weapons to be able to fight the state? Because state is much more powerful.
Right, exactly. It doesn't make any sense. And I think that it's one of the weaknesses of using the original intent to interpret the law and then applying it today is the idea that the Second Amendment, which was adopted in a time when weapons were pretty primitive, that it doesn't make sense to then say that we're going to apply that in a way that applies to now automatic weapons that can shoot hundreds of bullets in a minute. It's like saying that we're stuck with all the traffic laws from the days of the horse and buggy, because that's what the framers intended. So you can't have any traffic laws that are more restrictive than what would govern a horse and buggy today when you have automobiles, that can go 150 miles an hour. To me, and it also having to do with the rights of women. The history of abortion laws, they went all the way back, I think, to like 1300 in some of the things they cited. I mean, but up until pretty recently, women were considered property of their husbands and had no rights. So the idea that women's rights are shaped based on understandings that existed then, to me, it's just not the way to as we like to say, to run a railroad. It's not the way to govern. We should govern based on legal principles that make sense for today's society, not principles that made sense 800 years ago or something like that.
Yeah, and the court has said that we should look at the laws from 1700 and 1800s, and that is the regulation that can be allowed, not the one that we are proposing today. The difference that this new Supreme Court ruling has created, I understand, is that in 2008 it was said that they have a right to have those guns in their homes for their own safety. Now they're allowed to carry those guns in public space. Is that right?
Yeah, so they decided that open carry laws are unconstitutional, guns that prohibit you from carrying your weapons outside of your house. And I should point out that one of the problems with all of the Supreme Court's gun decisions is that they state absolutely no legal standard for determining what laws are allowed and what laws are not. It's sort of left to the lower courts and to the state and local governments to guess what they're allowed to do and what they're not allowed to do. The court has not even tried to create a standard for evaluating the constitutionality of gun laws. So that makes things very difficult. So we have this situation now where we have a terrible problem of gun violence in this country, and the Supreme Court, on a case-by-case basis, with a majority of 5 or 6 people, is deciding which laws the state and local governments are allowed to have and which they aren't. And I don't understand where they think they have the expertise on how you make society better in light of all this gun violence that we have, and where they get the power and the legitimacy to do that. It doesn't seem to me to be part of their proper role.
Yeah, in light of what's happening, we're looking for more gun control, and we see the courts making it, difficult, more and more difficult to regulate day by day. Jack, it's time for a break, and after we come back, we're going to talk about another very important Supreme Court decision, which talks about environment and is making it difficult to regulate, environment protection as well. We'll take a short break here. ਤੁਹਾਨੂੰ ਮਿਲਦੇ ਹਾਂ ਛੋਟੀ ਜੀ ਬ੍ਰੇਕ ਦੇ ਬਾਅਦ। ਤੁਸੀਂ ਵੇਖਦੇ ਰਹੋ The Way Forward। The Way Forward is ਤੁਹਾਡਾ ਫਿਰ ਤੋਂ ਸਵਾਗਤ ਹੈ। ਮੈਂ ਤੁਹਾਡਾ ਹੋਸਟ ਹਰਜੋਤ ਸਿੰਘ। Jack, another judgment of the Supreme Court, which is going to have a very long-lasting effect on the regulation in this country, is West Virginia versus EPA. And the important aspect of this is that the court has said that agencies of the federal government cannot regulate on some things. It is always the Congress that has to do there. They have given a theory also. I would like you to throw some more light on this. How significant is this decision?
Well, what the Supreme Court did in the particular case was say that the Environmental Protection Agency does not have the authority to try to force utilities to change what sort of fuel they burn. So to stop burning fuels that have high greenhouse gas emissions and switch to some other sort of power, whether it's hydroelectric power, solar power, wind power, or cleaner sources of fossil fuels like natural gas away from coal. And in the course of doing it, the court announced a doctrine which it had hinted at before, but it made it much stronger now, which basically says that when there's a major question that comes to an agency where it's not clear that Congress gave the power, that the court's going to presume that Congress did not give the power, and that it's only Congress can authorize an agency to make a major change like this in the way it regulates. And that's pretty striking because as things in the world change, agencies need to have flexibility to adapt what they're doing to new circumstances. And it goes back also not quite as long as Roe versus Wade, but about 40 years ago, the Supreme Court made a very important decision in an environmental case where it said that when a statute is unclear, when an environmental law is unclear, and really it said it for any law, when a law is unclear about whether the agency has a certain amount of authority, then it's going to leave it to the agency to decide whether to exercise that authority. As long as the agency has a reasonable understanding of its authority, that's going to govern. And they repeated that in the first big global warming case. There was a case that Massachusetts brought against the EPA for not regulating greenhouse gas emissions in automobiles. And the government's defense was, we don't have the authority to do this because our law doesn't clearly say that we do. And the Supreme Court said, no, the law doesn't have to clearly say that it does. It just has to be a reasonable interpretation of what the law says. And by saying that you have the power to regulate air pollutants, you have the power to regulate greenhouse gases, because greenhouse gases meet the definition of an air pollutant. So, but in the meanwhile, there were a couple of cases that seemed to go the other way. When the Food and Drug Administration tried to regulate tobacco to keep children from smoking, basically, and to limit the placement and advertising of tobacco products, the Supreme Court said, well, that's an extraordinary question. There's so much controversy about tobacco that only Congress can grant the authority to do that without. And since the Food and Drug Law didn't specifically say that Congress could grant that authority, then we're not going to allow the agency to. Since Congress didn't specifically say that the agency had the authority, we're not going to let Congress do that. And it did that again in another in another case about the Affordable Care Act. It said that it wasn't going to give any sort of deference to how the government read the Affordable Care Act, because it was such a major question whether the Affordable Care Act was constitutional and whether it was authorized by the state, what they were doing was authorized by the statute, that we're going to do an independent judicial decision about whether the agency has the power. So basically what you had in this West Virginia case, which has ramifications across the entire government, what you have is the Supreme Court basically saying if any agency that wants to do something major, anything important, in a major area of government concern, that they have to have pretty clear authority from Congress before they can act. And that's just an unrealistic task to impose on Congress, and especially the Congress we have today, which seems to be reluctant to do anything. It's very, very difficult to get Congress. We talk about gridlock in Congress. The Congress is more divided now than it ever has been. Some people say even more divided than right before the Civil War in the 1850s. So The problem then is that you have a situation where the agencies can't do anything, the president can't do anything, and Congress won't do anything. And so you basically could have terrible environmental problems fester without the ability of the government to deal with them. Mm-hmm. And it also carries over into other areas. For example, there's a concern at the Securities and Exchange Commission that some of their big initiatives in enforcing the laws that they administer to prevent securities fraud and bank fraud and such, that they're going to be in danger. And the Consumer Finance Protection Bureau, which enforces provisions that were passed after the last financial crisis in the like around 2007 or 2008, that those laws are going to be at risk. The agency's actions, because the Supreme Court is going to require that Congress give very specific authority before the agencies can act on their own. And that really reverses 100 years of almost 100 years of the understanding of agency authority under the law, and makes it much, much more difficult for the federal government to regulate. And in most important areas, in the environment and in financial regulation and such, consumer safety, it's really important to have federal regulation because unsafe products travel across state lines, pollutants travel across state lines and affect the whole world. Securities fraud occurs across the whole country and such. And so it's going to make, if this decision has the potential to make it very difficult for the federal government to have effective regulation, which could cause big problems for the average person. Corporations, big companies are happy because they make a lot of money off of defrauding people and selling them unsafe products and polluting because they don't have to pay the costs of their own activities when they send pollutants out into the environment. But for the average person, it's a very bad thing. You imagine worker safety also under the Occupational Safety Act, which is a very general law that protects workers and their jobs. And if the Supreme Court says that the Department of Labor needs very specific authority to take strong actions in favor of worker protections, it's going to just harm the average person, the average worker, at the expense of profits for the big companies, and down the road it could cause terrible environmental problems.
Yeah, we see this trend that the conservatives have always been talking about less regulation, and we see that through these these recent decisions, they're making it more and more difficult for the government to regulate, because Congress, particularly the Congress that we have today, cannot regulate on each and every matter, and these agencies definitely have direct dealing, more scientific, more modern, more recent data to tackle these situations. Another thing, which is the underlying factor for all of these decisions, is this theory of original intent, the originalism. I don't understand, Jack. Jack, I'm an immigrant, and I was talking to you earlier about this. We've always seen U.S. as a society, as a country, which found solution for hundreds of years of problems which society was having. There's all men are created equal, so that people can participate in the government, bring the government to the lowest levels. Those were solutions to problems that developed over a period of time, and now. Are we looking to be stuck for the next 5,000 years, next 2,000 years with what we thought was right 300 years back? The society progresses, times changes. Do you agree with what I'm saying here?
Yeah, I'm not a big fan of original intent. I mean, I think that the Constitution has the status of law. So if the Constitution clearly says something, like the president must be at least 35 years old, then that's something that ought to get followed. But in terms of the more general notions of what powers Congress has to regulate, those clauses of the Constitution are vague, and they were made vague on purpose so that the government today would decide what it ought to do. The people today ought to decide what to do, not 9 relatively unaccountable justices in the Supreme Court. And so you have the idea that we can sort of turn back the clock and go back to a legal system that only allows the government to do what it was allowed to do in 1789 or maybe 1870 when you look at the Civil War era amendments, which were the last big amendments. To me, that's very unattractive. And that's not the way. Nobody would run their lives that way. Nobody would think, well, it's my grandparents did it this way, so therefore I must do it this way, right? Nobody would say, well, I guess there are some groups, but my great grandfather only owned a horse, so I'm only going to ride a horse to work. And they didn't have television when my father was a child, so I'm not going to watch television. Or, computers are a newfangled thing. I can't use a computer. It's not. To running a government like that is even worse, because basically what you have is government officials sacrificing the public good on the altar of some sort of ideology. And to me, it doesn't make sense. It seems inconsistent with the basic sort of fiduciary duty of the government to try to make lives better and improve society. And I think that's the biggest problem with originalism, is it's inconsistent, in my view, with the basic obligation of government officials to act in the public interest, not act based on some abstract theory of law that they may have decided was the best theory when they were in law school or something like that.
Jack, we have ran out of time. We thank you so much for taking out the time today, enlightening our viewers, enlightening all of us, with these very, very significant and very, very important developments.
You're welcome, Harjot. It was my pleasure.
Thank you so much. AC, ਸਾਡਾ ਅੱਜ ਦਾ ਸ਼ੋਅ ਤੁਸੀਂ ਵੇਖਦੇ ਰਹੋ, The Way Forward.